Can you hear us?
Ви нас чуєте? Будь ласка, перевірте зв'язок з кандидатом та звук. Ви чуєте нас, пане Віталій?
Я вас чую, да.
Good morning. I can hear you, yes.
Затримка просто в сигналі.
There has probably been a short delay in the signal. I was just listening to the Ukrainian channel. Yes, but that's what you are supposed to do. Thank you.
Вітаємо вас на другому
Welcome to
етапі
stage
конкурсного
2
відбору
of the selection to be appointed as member of HQCJ.
Комісія проводить у повному складі.
So your interview will be conducted by all of the members of the commission. Let me introduce my colleagues: Robert Brookhuizen, me, Ivan Mishchenko, Tadza Zhechny, Serhiy Varlanov, Steven Markman, and Evgen Mezintsev. The rapporteurs for your interview are me and my colleague Tadza Zhechny.
Пане Віталію, якщо з якихось
So, Vitaly, if for some reason the broadcast is interrupted because of a power outage, lack of internet connection, or an air raid alert, the Commission will reach you and will resume your interview on a different day and at a different time, starting from the point where we've interrupted the interview.
час інтерв'ю прохання відповідати.
During the interview, we are kindly asking you to be very precise and brief in your answers, and the Commissioner asking you a question has the right to limit the duration of your answer. That's quite natural.
Власне, на початку інтерв'ю
And at the very beginning of your interview, you are given an opportunity
провести таку саму
to introduce yourself. You will have up to 5 minutes to do that. So please tell us more about your motivation, about the ideas
вашої можливої
that you have should you be appointed as a member of HQCJ. You're welcome.
Дякую дуже, пане головуючий.
Thank you, Mr. Chairman. Good morning, dear commissioners. Thank you for the opportunity provided to me to introduce myself. I'm Vitalii Hatseliuk, and my professional background consists of 3 components. This is scientific and research activity in the field of law. This is the lawmaking experience and project management in the field of legal reform and reform of the judiciary. As far as research activity is concerned, I've been dealing with it since 2002 when I entered the adjunction department in Luhansk, and in 2005 I presented my PhD thesis in criminal law to get my degree of PhD, and I've been working within this field over this period. I've got a number of scientific papers, some of them in co-authorship, and some of them include comments to the criminal code and the code of criminal procedure, monographs, articles, and speeches at conferences. Over the recent 8 years, I've been holding the position of the Senior Research Fellow of the Department of Problems of Law of the Institute of State and Law of the National Academy of Sciences of Ukraine. And in December last year, on the basis of this activity, I got the degree of Senior Fellow, Research Fellow in the field of law. In 2007 up to 2014, I worked in the Secretariat of the Committee of the Verkhovna Rada on legal provision of law enforcement activity. And the field of activity of this committee includes a wide range of issues in the field of criminal law and organization of the work of law enforcement bodies. Or any of such bodies, whatever we call them. This has been a very important committee from the point of view of its performance, efficiency. It has always been among the 3 top ones in terms of the number of legislative acts passed. And I, together with my colleagues, was responsible for working at draft laws, preparation of hearings at the committee, in the parliament, and for exercising control over this activity and over development of different policies. So this experience was really interesting. And the third component is project management in the field of reform of law within their mission of the international organization, because since 2014 I've been manager on legal reform in the office of the OSCE coordinator in Ukraine. And within our project portfolio, we have such partners as the Constitutional Court, the Supreme Court, the High Anti-Corruption Court of Ukraine, the State Investigations Bureau, the Security Service of Ukraine, parliamentary committees like Committee on European Integration and Committee on Legal Reform. And Also, while performing those projects, implementing those projects, we cooperated with a number of partners in the field of legal and judicial reform. Among the achievements, I would probably indicate launching of the High Anti-Corruption Court, because our organization had something to do with the development of the relevant materials, conceptual materials, before we developed the respective law on the High Anti-Corruption Court. We also had something to do and are still having something to do with cooperation with this institution. Also, within different project implementation, we managed to build systemic and consistent platforms for professional dialogue of the members of the legal community. These are different forums, conferences, and unconventional events like the Constitutional Week, when in June, on the Day of the Constitution, we organized annually not just typical international conferences, but some new formats like the constitutional cafes, where young people could have a chance to discuss current issues and problems related to constitutional judges. Well, in this way, we are creating the ecosystem for professional dialogue, and I think it's really a matter of utmost importance. Another issue which is so far not in the focus of attention of the society is the issue of gender equality in the field of jurisprudence and law, and we have managed to launch, as I think, a powerful discussion, because we had something to do with the publication of some articles related to the problems of gender in constitutionalism. We supported civil society organizations that work in this direction. And I also was involved as a reporter on that. I was thinking together with my colleagues about the problems, about the relation of gender problems to the field of integrity, and my idea actually was that if we speak about the judge, he or she can hardly be considered to be a man or a woman of integrity as a judge, and not just an ordinary citizen, if he or she does not follow the issue of gender equality in his or her life. This is reflected in the international discourse, in the international documents, but in Ukraine, colleagues do not always understand that the issue of gender is not about sex, but about access to power and resources. And as far as my motivation is concerned, here are 2 points. First of all, for 16 years, I've been dealing with the legal reforms and judicial reforms in general. And we have managed to develop a lot of interesting recommendations and give them to the national stakeholders, but unfortunately we were not always heard. And it seems to me that it's high time that we undertook the responsibility for the implementation of the recommendations that we gave. We should already start bringing them into life. And the other component of my motivation is related to the ongoing war, in the sense that, of course, that is a great tragedy, an awful tragedy, but at the same time, that is a unique window of opportunities. After Ukraine gains victory, this window will be closed. But now, the society really has zero tolerance to injustice and fairness, and it is right the time for quick and effective reform implementation. After victory, that will be more difficult to do it, because we will have ordinary political life and some opportunities will already be lost. So I think that in total, this is my professional background and this is my motivation why I'm here. Thank you. Thank you, Vitaly.
Як взагалі інтерв'ю дивилися?
Have you been watching the previous interviews? Well, not that much, to tell the truth. Well, I don't think that that would be the right approach. And to tell the truth, if we speak about improvements, I would rather record the interviews, but I would not broadcast them live, because psychologically it may distract you. For example, well, I could not actually watch the interviews because of my workload, but also psychologically, I was not that much ready to listen to the questions you asked other colleagues. It seems to me that it would have distracted me, but I watched some parts. In particular, in the interviews of the colleagues I know better. And have you been getting ready for your interview? Well, yes, sure, because we are all involved in settlement of a number of issues, and from morning till night, the judicial reform is in the focus of my attention, so I just had to refresh my understanding of some issues that we could actually focus on. So let's start with the judicial reform. You've been dealing with it since 2014, and you have a great experience as an expert, as a person who is involved in project management. You have given the example of the High Anti-Corruption Court as a successful reform. Please give us an example of an unsuccessful, a failed reform, and what was the reason for that failure? Well, thank you for the question. I really think that beginning of the work of the Supreme Court and High Anti-Corruption Court is an example of success from the point of view of the procedures, selection procedures, and the results of performance of those two institutions. Several days ago, in Facebook, I saw the results of the High Anti-Corruption Court. Well, it published the results of its performance, and I think that this could be considered to be a success story. As far as failure stories are concerned, well, this is the reform of the law enforcement system. There are a lot of components involved in that reform. I think the reform has not been completed, and it is a comprehensive one, and it includes the issue of bringing up staff. It includes proper and adequate funding, development of the institutions, and here we could give an example that while in 1995 Ukraine was joining the Council of Europe, one of its commitments was to actually change the functions of the prosecutor's office and to also change something with the function of investigation. That was in 1995. And only when the State Investigation Bureau was launched, the investigative offices were liquidated within the prosecutor's office. So it's a rather simple thing, but it only appears to be simple because it couldn't be resolved for a long period of time. And that was related to the lack of political will, because, you know, politicians quite often try to use the law enforcement system to accomplish some of their political objectives. So I could actually continue with this, but that's the short answer. It's more or less clear what we should do with the law enforcement system, what we should do with the security service, what should be the functions of the security service, how the Bureau of Economic Safety should work, what the State Investigation Bureau should focus on. And here is the example of military police. Now the State Investigation Bureau has to investigate war crimes, but that's because we don't have the full-fledged military police. Clear, but and do we need military tribunals? Yes or no? Just in brief, I think no. I think that the judiciary can actually cope with the special features of considering criminal cases with some military elements, and they will be capable of having a look at the statutes and involve experts and passing good decisions. In your motivation letter, you mentioned that the work in the OSCE, and probably not only it, gave you an impartial view of the problems in the judiciary. If you could clarify what you meant by that, what problems do you see in the functioning of the judiciary? Well, thank you. Again, these are the changing issues that keep being discussed. I think that the core points determining the problems in the judiciary and lack of completion of the judicial reform are staff shortage and quality of judicial staff, problem of funding, problem of trust in court, and problem of enforcement of court decisions. Just in brief. Okay, clear. Thank you.
Ви також, продовжуючи ваш мотиваційний лист, ви
To
зазначаєте, що
continue with your motivation letter, you indicate that your first priority as that of the member of the HQCJ would be a dialogue with the society and development of judicial dialogue and development of soft skills and communication skills of candidates, judicial candidates. By the dialogue with the society, do you mean yourself as the member of the HQCJ, right? Well, yes. My contribution into the development of the activity of the HQCJ would actually lie in development of communication. And what about judicial dialogue? What do you mean by it? Well, as far as judicial dialogue is concerned, I would say that this is the dialogue inside the judiciary. And let me give you two examples. The first example is from December 2016, within one of our initiatives called Dialogues on the Judicial Reform. We organized an event in Severodonetsk. This is close to the area of hostilities, and people from the government rarely came there. And the amendments to the constitution had been adopted, qualification assessment had been started. So within those dialogues on legal reform, we organized an event in Severodonetsk, and the member of the HQCJ and the High Council of Justice came to the legal community and judges from Luhansk and Donetsk regions. And they told about the goal of the qualification assessment, the objectives, the parameters, the criteria, methodology of qualification assessment. And these representatives of the HQCJ and the High Council of Justice saw the real conditions in which some courts and some judges had to perform their work and to function. So there took place this judicial dialogue I've been talking about. And now, while organizing qualification assessment, we should probably take into account the peculiarities of functioning of the courts that are close to the area of hostilities. This should be taken into account by the HQCJ while organizing specific procedures. And the other example is that last year we had an event where the judges of the High Anti-Corruption Court, together with the representatives of the cassation instance, could discuss the standpoints, legal standpoints of the Supreme Court, predetermine the issues which have not yet been settled, and tell how, from the point of view of jury access to justice, they could consider the challenges that arise, in particular in the work of the High Anti-Corruption Court, within consideration of specific categories of types of cases. So I think that this dialogue is really precious and should be developed. And what is your suggestion concerning the establishment of such dialogue at the level of appellate courts and trial courts? Because it's clear with high courts, they actually do have this commitment to actively participate in the communication. But what about trial courts and appellate courts? These are the courts the society mostly has to deal with in daily life. Thank you for the question. I think that we used to have some regional... well, I'm sorry, I'm going to interrupt you. I've been just informed that there is air alarm. Are you in a safe place? Yes. Good, so let's continue then. I just say that the trial courts and appellate courts should have a dialogue in between them. And from my experience of organizing different events in the regions, I can tell that this can be done thanks to the events organized by international partners. But I also know from my communication from judges that they hold the judges themselves organize some discussions, and appellate courts discuss some problematic issues with the trial courts. And it's good to also sometimes involve the prosecution side and the defendant side, the lawyers, into this discussion. So I don't think any things that would be impossible. And I think that in the regions we have different platforms and grounds. They got called in different ways. Sometimes judges themselves organize these platforms, sometimes their partners help them with this, but they have this professional ongoing dialogue. I've got acquainted with the article on Article 375 of the Criminal Code and the decision of the Constitutional Court under this article. As far as I understand, you're rather critical about the decision of the Constitutional Court, and generally, as far as I understand, you do support the need for having such article. We are talking about miscarriage of justice, about unjust decisions. So do you know that judges are majorly highly critical about any wording for this article because they consider it to be a threat to judicial impartiality and a possible tool of pressure? Yeah, sure, I do know about this. Thank you for the question. I think that if we theoretically just imagine the situation, well, first of all, what is unjust decision or miscarriage of justice? Unjust decision or illegal decision is the one that does not correspond to the norms of procedural substantive law, and which is the grounds for canceling the decision. I'm sorry, Vitaly, but if I cancel decision of the courts of trial or in appellate courts as a judge of the Supreme Court, I sometimes indicate that there have been violations of the norms of substantive or procedural law, but I don't always run to the conclusion that this is an illegal decision, miscarriage of justice. I just disagree with courts. Yes, you're right, but the norm of criminal code also included this word purposefully or consciously unjust or illegal decision. So if it is established that it was consciously or purposefully illegal, that when the judge realized that he's doing miscarriage of justice contrary to the norms of the law, and he did this with direct intention. So if we have such a situation, this is a socially threatening situation, and the Criminal Code has Article 11, which says that the action which is formally within this description but does not possess this degree of societal threat is not considered to be a crime under this article. But I think that if we speak about consciously illegal decision, there is a great threat for the society. And by the way, the Consultative Council of European Judges claims that we could not introduce criminal responsibility or any types of clear responsibility for careless actions of judges, but there is no recommendation concerning, no such recommendation about purposeful or conscious ones. I don't mean that all the decisions cancelled by the cassation instance should be the grounds for cancelling the decisions or for giving this case within this article, but the practice of application of the article of the Criminal Code should not always lead to the conclusion that this is an unconstitutional article or something like this. Clear. It's. I've got your standpoint. Please, Ted, the floor is yours.
Thank you, Mr. Chairman, and good morning to you, Mr. Hatseliuk. You raised the issue, or the issue has been raised with you with respect to gender equality, and we had a very interesting discussion with another candidate, a woman who also had some views with respect to the importance of gender equality in many institutions in society, and of course, in particular, the judiciary. I wonder, can you share with us any ideas that you might have as a member of the High Qualification Commission of Judges, should you be appointed to that body? Any ideas that you have that would promote or increase the involvement of women in the judiciary as the HQCJ?
Дякую дуже.
Thank you for the question.
Що в системі судової
I think that in the
системою правоохорони
judiciary, if we compare the judiciary with law enforcement bodies, we actually do have much more women, but and who are much more women who work there and actually have to perform some functions. But the question is whether on the top positions we have the same number of women and men. I probably don't have the statistical data, but I think that we should pay attention to this. It's not the function of the HQCJ to determine who's going to be the court president or the chairperson, but anyway, these are the issues that should be raised within the trainings organized by the National School of Judges of Ukraine, which is kind of controlled by the HQCJ. So I think that these issues should be included into the curriculum, into different trainings, and we should also hold some practical events, exchange experiences with partners from the EU countries, because Ukraine is actively moving towards Europe. And in that way, at the stages of qualification assessment, at the stage of training and advanced training of judges, we should also raise those issues that will also embrace such elementary things as motherhood, while assessing the number of decisions and the efficacy of decisions passed by the judge. I think that we should take into account the difference between a single father and a mother who has 3 children.
I'm not sure you understood my question. Let me try and rephrase it. I'm interested in any ideas that you may have for the High Qualification Commission and anything that it could do in terms of its evaluating or the criteria that it uses to evaluate candidates for the judicial appointment, favoring women. Would you be supportive of such an approach, or do you have any other ideas?
Thank you. I was actually trying to cover this issue in the context of the mandate of the HQCJ. But if we speak about the selection of judicial candidates, if we narrow down this issue, I would say that favoring women, promoting women in the form of the so-called positive discrimination doesn't seem to be the right approach as for me. I would still keep to the principles of equality here, but at the same time, the HQCJ cannot but take into account the special characteristics of ladies when they have to bring up children and some other things, which also affect professional experience and background of women. That must be taken into account. There must be the methodology and the criteria for that. But favoring women, no. Just because of the gender, I wouldn't do that.
All right, thank you for your answer. I am very interested in the career that you have spent now on behalf of the OSCE. And I'm wondering, quite apart from the general activities of the OSCE, you personally, in your engagement with the OSCE, what of your experiences would you say make a contribution to the work of the HQCJ should you be appointed to it?
Дякую.
Thank you for the question. Well,
Зануритися у так
it
звану
was a new thing for me to go deep into the so-called field of project management. I went to the OSCE after several years of working as a civil servant in the parliament, in the Verkhovna Rada. And, you know, the peculiarity of this work was that you have more or less permanent functions, draft laws keep coming, and you actually perform the same things on a daily basis. I liked that work, the job, and I could actually feel some sustainability for many years. But when I came to the OSCE and started working in project management, that project approach started dominating. The project approach means that you determine the problem, the necessary required resources, like in terms of time, people, and stuff. You determine the criteria and the indicators which show whether you have settled this problem or not, and you're moving forward. And after the end of the project, you make an evaluation, you determine whether the problem has been solved or not, and you either launch a new project or you have a follow-up to this project, the next phase. Psychologically and operationally, that was different. An understanding of the fact that a certain project will always be completed was a new thing for me. And I think that this will be useful for me. I can see that now in state authorities, they're also applying this approach of project management. And I think that this will be useful because this allows to actually adjust to the situation which is rather dynamic. And it is application of projects in the activity of state authorities, in particular in the activity of the HQCJ, and the understanding of this approach, experience of working within this approach would be a useful thing that would come as my contribution to the HQCJ's functioning.
Thank you. You spoke more than once, Mr. Hatseliuk, about the apparent success, as you have concluded it to be, and I think that opinion may be shared, with respect to the operation and the process for the appointment of the Supreme Court and the High Anti-Corruption Court. And I would be interested in having you tell us why you think those two courts and the process for the appointment of those two courts worked well and appears to have been appreciated and recognized as successful.
Thank you for the question. Well, the selection procedure for the Supreme Court and the High Anti-Corruption Court were a little bit different, but they were united in one element: involvement of the public, of the civil society, and international experts in the selection process. I think that that was a new experience that was very useful for Ukraine. And on the basis of this, it was possible to start solving one of the major problems we have been discussing in the system of the judiciary. This is trust in the judiciary, in the court. I think that happened because of the involvement of the international experts and civil society. As a result of that, the level of trust was higher, and the activity, the performance of those organizations also was better as a result of correct communication of the results of these selection procedures. So it seems to me that these courts and the judiciary in general are moving towards raising the level of trust, societal trust in the judiciary, which is really now important to ensure proper functioning of the judiciary.
Thank you. I'm going to pass the matter back to our chairman then, and there are other members of our commission that will also have questions of you. Thank you for your answers.
Thank you, Ted. Well, let's start with you, Stephen, right?
Thank you, Judge Mashenko. Mr. Hatseliuk, looking at your motivation letter, you emphasize that you have the benefit of having looked at things from a variety of perspectives. And you talk about the lawmaker's perspective and the scientific perspective and the practical perspective and the OSCE perspective. And these are impressive perspectives, and they all no doubt contribute something different to your thinking. But then I see what's been produced by your perspectives, and Judge Mashenko mentioned some of these. You talk about dialogue and you talk about looking to the future. But I think about Churchill's famous memos during World War II, where he sent to his associates on a frequent basis, action today. When does the action come? What are your priorities? What does he want to do? Is there something on the first day you want to achieve, or maybe on the second or the third day? I mean, I think it's great to have these perspectives, and you really do have a broad variety of perspectives. And of course, dialogue is always a good virtue in this kind of circumstance. But what is it eventually that you want to do when you get to the action part?
Thank you. I fully support Mr. Churchill, by the way, and I think that the HQCJ really faces some urgent issues that must be settled. First of all, that is completion of the qualification assessment that was started in 2016. As far as I understand, about 2,000 judges have passed qualification assessment, and then for clear reasons it was terminated. But we need to complete this process, first of all, due to the principle of equality for all the other judges to follow the same procedure, following the same standards. For example, now in the European Court on Human Rights, as far as I know, there is the statement made by one of the participants of the competition to the Supreme Court, and he claims that the rules were changed during the competition. Probably it's wrong to change rules during the competition and not to postpone with the completion of qualification assessment. We should do this following the same rules, but as quickly as possible. The way we did it for, not we, but it was done for many judges. And the other problem is overcoming staff shortage in the trial instance and appellate instance. And again, this is my experience of working in the OSCE. We visited a lot of appellate courts, and judges of the region, I'm sorry, problems with connection. Technical problems, right? Can you hear me? Vitaly, the point is that the connection was interrupted. Let's try to give another call to the candidate to improve the connection, and in the meantime, let's have a short break.
No. That's yeah. We have to pull him again. Дякую, ми відновили зв'язок.
Thank you. We have restored the connection. Can you see and hear us? Is everything okay? Yes, I can see and hear you. Good morning once more. So let's continue.
Так, я говорив про
So,
набір.
I was trying to tell you about the completion of the qualification assessment, about the appointment of judges for trial courts and appellate courts, appointment of judges to the court for intellectual property rights.
І, напевно, на цьому нагальні питання. Да, і плюс
And probably these are the most expedient things. And we also know that in connection with the war,
в тому числі можливість
we now have this need and also the opportunity
посилити спроможність
to transfer judges from one court to another court to reinforce some of the courts because we have the occupied territories. As far as I know, this was the mandate of the Supreme Court, but once we have the HQCJ, it will be able to solve this problem. Thank you.
Can I just ask you, during 2022, my understanding is that you crossed the border into Hungary on at least 3 occasions. Is there anything about that we should know?
Так, це були службові відрядження.
Yes, those were business trips that were part of my work for OSCE. In May and in June, I traveled there for the sessions of OSCE. We were discussing the continuation of the mandate of the OSCE mission, and at the time I was manager of the project dealing with humanitarian aid, and my expertise was requested there. So I was asked to be present for some consultations, and in September I traveled to Vienna as part of this project as well, because we were delivering some equipment to our partners and there were some organizational issues with the transfer of the equipment from Vienna to Ukraine. So those were short-term business trips.
Okay, well, those are certainly good explanations. Finally, have you ever had your certificate of the right to practice law suspended? There was a problem apparently in not having that declared in 2021, failing to indicate your membership in the National Association of Lawyers. Was that just an oversight, or do you no longer have that certificate?
Так, воно не було припинено.
No, it was not terminated. The certificate is in effect. So my license actually to practice law was withdrawn because as a result of the reform of 2016, we've had this monopoly of lawyers, and that's why as a result, only attorneys at law were able to represent the interests of individuals in court. So I made this decision that it would be of use to have somebody with a certificate to practice law as part of our staff so that the interests of the organization could be represented. That's why my certificate was not terminated, but I'm not actually practicing law. I do have this certificate, but solely for the reason if there's a need for me to represent the organization I'm working for. So I've not applied for the competition as an attorney at law, so I'm not even trying to pretend that my practice in law should be added to my general experience of working.
Well, thank you again, Mr. Hatseliuk, for that clarification. I've got no further questions.
If I may. Я вибачаюсь, питання мого колеги стосувалося
So my
того,
question
що за даними
indeed is about some civil society organizations saying that you did not declare your membership in the National Bar Association of Ukraine.
питання полягає
So the question is more about this.
ви його не задекларували, тому що
Did you not declare this certificate because really why? Well, I understand your question now. Indeed, I did not declare this certificate in my declaration. It was my first time filling out the declaration. Maybe I just skipped it, but this information is available on my LinkedIn profile. And you can find this information in public access. Yes, I did not declare this certificate, but I'm not hiding it. Thank you. Thank you. On many occasions, we have stressed that we are very meticulous about people filling out declarations, and that's why absence of your membership in some associations cannot be any ground for your dismissal. You will just have to rectify this mistake. That's why I don't think it's really that important. But at the same time, Vitaly, I want to tell you that we are really happy that we are seeing a very progressive young man in front of us, a man who is passionate about the judicial reform, not just in words, but also in their actions. And you are a person that is highlighting Ukraine while acting for international organizations, enhancing the prestige of Ukraine. So we have this question for you. In foreign countries, I was talking to my colleague from a circuit court of Amsterdam, and he told me that he was having a professional blog on Facebook. And in that blog, he writes about some of the decisions that he's made, sometimes even with explanations, and he's active in talking to the commenters of his blog. So he is explaining the decisions made by him to the public. So, in your opinion, should Ukrainian judges introduce or maybe borrow from this experience of their foreign colleagues? I mean, having a professional blog. Or should the judges limit themselves to some personal blogs and not highlight their professional activities on social media? So where should we find this balance, in your opinion? Thanks a lot for the question. I think that the balance should be in finding the golden mean between the need to inform the people about the activities of the judiciary and not trying to have discussions on the level of blogs, because they can easily go beyond the acceptable limits. The issue of communication in the judiciary is extremely important. I do remember our experience of cooperation with the Supreme Court, and we had the honor in helping organize the Facebook page of the Supreme Court, which for some time was the sole channel of communication of the decisions made by the Supreme Court. And back at that time, I was the witness of quite harsh debates between those judges who were preparing the decisions, and they took a lot of time to prepare those decisions. And there were also specialists in communications who said that the decisions didn't have to be that complicated. I think there should be a balance between complicatedness of the decisions, and at the same time, people should be able to understand what they are about. So it's also about the psychology. Some people like this, some people dislike it, but I like communication done by judge speakers. These are people appointed for public communication. They do have the necessary skills, because in order for communication to take place in the right way, you also need to have the experience and skills necessary. So I think that having blogs by judges is something that we can have, but on the level of the system, we need to develop soft skills as part of judicial competence. And also we need to have some coordinated channels, and we need to have judge speakers. This system is working quite efficiently via judge speakers. But what's your opinion about personal blogs run by judges? What are the limits to those personal blogs? And is it even justified for judges to be that open in highlighting their personal life to the society? Do you mean a blog about their personal life? No, I'm talking about social media pages. Let's say a page on Facebook or Twitter. Oh, look at me. This is me having breakfast. This is me traveling somewhere to the KFC, etc., etc. So, this type of communication done by a professional judge, how acceptable is it? And can it support the authority of the judiciary? Thank you. Now I've understood the question. This type of communication on social media and in blogs, just like any other non-professional activity of the judge, should meet the criteria of judicial ethics. Yes, we do have very general norms there, and hopefully with the development of information society, we will be able to develop these norms. But when we talk about any type of communication, regardless, be it a page on Facebook, and whether you are telling someone about your hunting trips or you're discussing something with your friends, both modes of communication should comply with the requirements set out for judges as people who need to meet the highest standards of ethics. Thank you. Let me also draw your attention to the issue of political neutrality, because in your materials we have found information that for quite some time you've worked at the Verkhovna Rada of Ukraine. You took care of the preparation of draft laws, and you were not involved with political parties specifically, but the parliament, the Verkhovna Rada, is the quintessence of the political life of Ukraine. Plus, your ex-wife, according to the data that the Commission has, in between 2006 and 2012, used to be an assistant to an MP, Mr. Malyshev. Can you please tell us, are you affected by the political life in Ukraine in any context? Are you a supporter of any political group? And are you openly in favor of any political movement? Because you've received one of your reference letters from an MP. Thanks a lot for this question. For all my life, I've worked for organizations where one of the requirements for getting the job is political neutrality. After graduation, I'm taking my oath as a worker of law enforcement, and I've also taken the oath as a civil servant. And while working for OSCE, I'm also following this requirement of political neutrality. The experience of working at the parliament, at the Verkhovna Rada, has given me a strong immunity against any political influences. And in the Secretariat, we only have civil servants who are bureaucrats. I've worked with different MPs of the Ukrainian parliament, and our committee was able to show the MPs that there are some political functions that are performed by them, and there are the functions done by the staff of the parliament. We are supporting them in their work. That is why I do believe that my experience is relevant. I don't have any political affiliations. I've worked with many MPs. We've discussed different draft laws. Maybe I was lucky, but within the activities of our committee, there was always this clear distinction between political interests and the activities of the parliament as a lawmaking body. Well, we are not trying to ask you questions that are too personal, but in general, the judiciary must be politically neutral and devoid of any political affiliations if we are talking about politics. That's why we would prefer to choose people who will be the selectors of the future judges and who will be as politically neutral as possible. Of course, it's impossible to be 100% politically neutral, but still, it's important that your political preferences are not being shown anywhere. And finally, this is a question asked from the civil society organizations, among others. So they are expressing some concerns with respect to your assets. They had some concerns about the value of your car, Volkswagen Passat, manufactured in 2013. With a 2-liter volume engine. So they are having the concerns that you bought the car for $10,000, but the average price of this car, according to civil society organizations, is much higher. They say it's at least $14,000, and we have the discrepancy in the price in between 16 and 19,000, which is the current market price. So could you please explain us the situation with this car? What's the price for which you bought it? What's the state of this car? So let me explain to you. I bought this car from my friend who was the second owner of this car, and he initially bought it from the car dealer. And first, the car was used for business trips. It was used quite extensively. It was a corporate car. So at the moment of the purchase, we decided that the price was justified because several months after I bought the car, I had to do repairs of the gearbox. That's why there is a simple explanation to this price. That's clear. Thank you for the answer. Vitaly, you have explained what the issues with the judiciary are. You've introduced some of the solutions. You've told us about your motivation. But I would like to ask you the following. Do you have the experience of working within collegial bodies that are dealing with selection? And if you have this experience, what is it? Yes, my experience of working in collegial bodies consists in working at the Secretariat of the Verkhovna Rada. The Secretariat is a collegial body consisting of subcommittees. I didn't have the right to vote as part of this committee, but for several years I was actively involved in preparation of issues for discussions prior to the sessions of the committee. That's why I'm familiar with the work of a collegial body. And how about the selection procedures? How about competitions? Well, within the committee, we listened to heads of other subcommittees, but while working for OSCE, I've been involved with recruiting. I know how the international organizations assess candidates, again, using the criteria of being unbiased. We know how the candidates are assessed, how the questions for them are developed, etc., etc. So you focused on the issues of the judiciary and the issue of the quality of judges. So should you be appointed member of HQCJ? In what way are you going to check this criteria, such as professional competence and integrity? But please be brief while answering your question. The methodology of qualification assessment allows for determining the criteria under which we check the competence. And that is the exam, the interview, that is a checking of the integrity. So all the criteria can be also found in the documents of Public Integrity Council and in other documents. So there are approaches as to how we check these aspects. Okay, that's clear. You're apparently knowledgeable, but should we change the methodology that we already have? Yes, of course, any rule with the development of societal relations may be changed. In my understanding, one of the greatest challenges of the judiciary is the European integration of Ukraine, and sooner or later, Ukrainian judges will have to apply European norms and standards. They will have to enforce them to a degree. That's why, if we talk about professional experience of judges, it's important that they understand the directive and the directives and the regulations of the European Union. That is something that should be implemented into the curriculum and later checked during assessment. Thank you. Any other questions?
Yes, sure. Robert Broekhuizen. When I listen to you, the first question comes up, because that's my area of interest, is that when you talk about judicial reform, you do not mention issues of corruption in the judiciary. And I didn't also hear any solutions about in that respect. Do you have any views or ideas, or whether this exists, and if yes or if no, what should be done about it? The perception of the Ukrainian people is that if you're rich, you will get better, you have chance of better judgments than if you are poor. You have any view on this?
Thank you, Robert, for the question. Yes, corruption is a fundamental problem, not just for the Ukrainian judiciary, but for Ukraine as a whole, and it's proven by expert assessment and the opinion of the public. And if we look at the recent surveys, as far as political transformations are concerned, many of them are focused on corruption. Today we are discussing integrity, and I do believe that integrity is one of those things that are necessary in order to prevent corruption. An anti-corruption body, which is NACP, and the Special Anti-Corruption Prosecutor's Office, the High Anti-Corruption Court of Ukraine, in my opinion, are efficient in solving the problems of fighting corruption, of preventing corruption. But in order to solve this problem on the level of factors, on the level of preconditions, it's important that we educate people. It's important that NACP does their job. The e-declaration is important, and the selection of judges is also important. The enhancement of their professional competence is of importance. These are the factors that should be working towards eliminating corruption in judiciary and in the country overall.
Okay. My experience up to date is, and maybe I'm wrong, that if you address or say the word judiciary within the two judges in Ukraine, it is like the elephant in the room. It is something that is not discussed or avoided. And there's also quite a lot of denial that it exists. And if you are appointed in the HQCJ, it's your job to address the issue, discuss it with the judges, and make sure that you select people who don't have those issues and are up to standard. So what will you do when you're asked to address this? Will you address this issue? Will you discuss it? Or do you have any other views about this?
Well, thank you for the question. I will talk about that. I don't see any other way out, and my experience of working in the parliament and working in project management shows me that if you don't speak about the problem, if you have any delays with that, you will just face it in the major size. So I don't see any problem in keeping it as an elephant in the room and not actually talking to judges about this. And my experience of communicating with judges of different instances, trial instance, appellate instance, Supreme Court judges over the recent years shows that actually there is no problem about discussing the challenges very clearly. And let me repeat what I mentioned at the beginning. now, even the period of time we live in makes us call white things white and black things black. That is the period of time when there is a window of opportunities for zero tolerance to unfair practices, to corruption. There is a social demand for that, and it seems to me that we do have all the conditions in place to discuss all the problems.
Okay. Well, if I think about this, is there not a risk that the judges within Ukraine will see you as a guy from donors because you work for the OSCE, which is a donor kind of organization? You're a guy who's representative of people who help Ukraine, and that means that at present you are talking to the judges as a representative of people who come bringing support and money, etc. But if you later are in the HQCJ, you are on the other side. You're in the judiciary system. So, do you expect the judges to accept you with your views and ideas?
Thank you for the question. Well, first of all, I don't see anything bad and special about my communication with judges now on behalf of the donor. Also, I've been communicating as a researcher with judges, and Article 375 has been mentioned today. So I had to communicate with the judges on the point of this article as a researcher, and we were discussing pros and cons of this or that decision. And also, in case I'm appointed a member of the HQCJ, this does not yet mean that I will be on that side of the barricade. I would not actually differentiate or make the opposition of the judges, HQCJ and High Council of Justice, and I will also not have this opposition, this division between the prosecution side and the defense side, because the Constitution actually includes the bar, the prosecutor's office, the High Council of Justice, and the bodies dealing with qualification and selection of judges and prosecutors to the judiciary. So it seems to me that this is just one whole system within which different institutions are performing different functions. So to conclude, just in brief, I don't see any problem about my further communication with judges.
Okay. If I look on the website of the OSCE, and of course I know that, but I just wanted to be sure that I don't say something wrong. It says, it explains what it is, and it explains many things, but it also explains it is a political organization. A political organization which has views about security, and one of the views they have is that the judiciary has to be enhanced because that's important for the future of economy and the security of a country. But it is a political organization. And of course you know that when you're in the HQCJ, you should be politically independent. How do you see that?
Well, again, thank you for the question. If we had more time, I would still discuss the origin of this organization and about its being its current, its past, and its future. It's the intergovernmental organization within which there is no legal commitment. I mean, there are no legally committing documents, and there is no court that could impose sanctions on non-enforcement of the decisions passed by the OSCE. That is, in a way, a unique organization. But these political commitments, political engagements within the OSCE are all the commitments that are based on the consensus. This is the decision of 57 member states of the OSCE. And only in this sense it is political, and this is political commitment. But I would say that this is political commitments and standards in the so-called third dimension, the so-called human dimension within the OSCE. And that is the criteria the commitments and standards that are mutually recognized. If we have a look at the OSCE's commitments, let's say in the field of the rule of law, we can hardly find there at least one that would be frustrating or that could be criticized from the point of view of prevention of its application. These are just the standards that fully comply with the standards of the Council of Europe, OSCE works with. So my work in OSCE, which is a political organization, will not actually prevent me from impartial performance of my functions from the political neutrality point of view in the HQCJ.
Thank you. I'll pass the floor again to our chairman.
Dear colleagues, do you have any further questions?
Maybe I.
Of course, sure.
Thank you. Пане Віталію, ви
So, Vitaly,
підняли досить
you have raised
болючу і
a rather acute and relevant problem related to corruption and ways to overcome corruption in our society.
гадаю, ви маєте
I think that you have to agree with the fact that to destroy corruption in the judiciary, not touching all the other institutions in this context, would be just something done in vain. So this should be systemic work related to all the fields of public life, public machinery as such. And the main thing is that the society should stop tolerating corruption, should get this zero tolerance. If people are ready to give bribes, well, let's just put it in that simple way. We will not overcome corruption. In the world, I haven't ever seen any single country where corruption has been eradicated. Corruption cannot be won over, since even through different executions of corruptioners on the Maidans, you can sometimes lead to even more corruption. But there are some countries where the level of corruption is at the level where this factor stops being the factor of influence and stops helping solve some problems at the top levels of state authorities and stop being noticeable for ordinary people. For example, these are Scandinavian countries, Denmark. The level of tolerance to corruption there is very low, but this is all about systemic work. So, what about your view? What does our country lack where we, let's be frank, we still have a lot of corruption and a rather high tolerance to it. So what is different in Ukraine from the Scandinavian countries? What could we borrow now that we have this window of opportunities, as you claim? Thank you. You are absolutely right in saying that it's not possible to eradicate corruption, to fully eradicate corruption. And corruption depends not only on the willingness of specific people to get some illegal enrichment, but it also depends, from the point of view of criminology, on the informal practice of allocation of the resources within the society. Corruption exists where official practices of resources allocation are not effective. Now, to get back to the issue of Scandinavian countries, there is a statement saying that when you build the rule of law, the first 500 years are the most difficult period to go. I think that the problem of Ukraine is that Ukraine didn't have this 500 years. And if we have a look at the recent 400 years, these global changes of social and political order and different state public developments that were arranging the life of citizens in this territory has obvious consequences. So if we don't have this time Northern Europe had, we have to use the best practices which were introduced there. Modern information society allows us to clearly determine the sort of practices and to determine their applicability in our conditions at the specific point of time, because, you know, probably one decision is more difficult to implement today, but in a year after there appear some factors preceding its implementation, it's going to be much easier to implement this decision. So prevention of corruption is the issue of ethics, education,
Ну, можна сказати, моди на доброчесність.
and kind of introducing the fashion of anti-corruption. This issue was not clear. Now people know what it is, and if we get back to the issue of the war, it is obvious why integrity and lack of corruption practices are important not just for a specific court, but for the state, because corrupt state cannot resist in the war. Yes, I understand. Vitaly, sorry for interrupting you, but
Я абсолютно погоджуюся з
I
тим, що
absolutely agree that we have to be transformed. And in order to
у нас немає 500 років.
enter the family of the EU, we don't have 500 years. We just have to do something now and here. And there are some steps like e-declarations.
Дуже широкого
And
контексту, який є обов'язковим і дійсно
in the wide context, and this is really a very important lever of exercising pressure on civil servants, and sometimes really they don't have the wish to be enriched illegally because they understand that they will be automatically subject to inspection or declaration of some assets because people have to report where from they have got their money.
на вашу думку, ну хоча б один
So, if you could mention at least one specific activity, one specific measure that would promote Ukraine in this respect. I understand education, training, things like that, they are important, but what could trigger further development? What could actually make our citizens stop
намагається вже боротися не перший
using this phenomena Ukraine has been fighting with for many years? Thank you for the question. It's actually easy to give the answer to it. If we have a look at the anti-corruption strategy and the action plan for it is being now developed, but the strategy clearly writes what we need to do. And by the way, some part of the strategy has already been fulfilled because it says that there should be the requirement of integrity for the members of the HQCJ and the High Council of Justice, and we know that this has already been done by legislation. So, as far as all the measures suggested by the strategy, I like that it suggests reducing the physical contact of the person who gives services and the person who gets services, like DIA and other tools. Thank you. Thank you.
Дякую вам за інтерв'ю, пане Віталію.
Thank you for the interview, Vitaly, and we would like to give the floor for the concluding speech on this interview. Maybe you want to
до чогось привернути увагу.
still draw our attention to something, or you have forgotten to say something, but you wanted to. So you just have the concluding speech, the basic statements, the way you would like to complete this interview. Thank you. Well, you know, the only thing I would like to say is to wish good luck to you. And from the point of view of the research, I would like to tell that you are performing a very important function. And the project, if we may call this a project, in which you participate, has all the chances to become a success. And my wish is just that you complete this procedure within the quickest period possible. And then the HQCJ will have a chance to perform its functions under the law. Thank you. Thank you to you.
На цьому співбесіда завершена.
So this is the end of our interviews. Thank you for your participation. Stay safe. Goodbye. Goodbye.